Hi y'all. It's week 8. We're going to talk about judges this week. Apparently, the continuing gremlins of CRJU 301 software continue to be predominant, and this will be take 2 of a video. Uh, Last week we talked about defense attorneys, and we finished up um, the written assignment on prosecutorial misconduct. I'm really looking for you to more deeply analyze issues than just the face of the prompt. Answering the prompt, as I've mentioned to several, will result in a C grade, and quite possibly a low C grade. By looking at things a little bit deeper, scores can be raised. The things that I think are notable in this question are definitions and rules, and where do those come from? When we talk about prosecutorial discretion and whether or not that is a codified issue, or should it be codified, meaning that the exact limits of that discretion be put in statutes, and that the federal system will listen to it, and the various state systems will. I didn't see much of a discussion about that, although that's something that should kind of pop out to you as you're thinking about the law, which, for the most part, the criminal law is based on the on statutes, things that the legislatures and Congress have passed. The next issue was the idea of ethics. The best papers laid out the American Bar Association rules on ethics, and then compared the district attorney's conduct to those statutes to determine whether or not there was actually ethical violations. The very best papers then talked about the lying to court and the things that Nifon was eventually convicted of and was sentenced to a short, but nonetheless, a jail time. And then the last thing is immunity. I really wanted to see you define immunity, and both the qualified, absolute and qualified immunity, what the two parameters were, what the when each applied, and where that came from. Again, I'm not pointing you right directly at the things I want you to do, but I also do want you to spend some time analyzing the papers, and not just produce a report. I mentioned that in a lot of the feedback, and I kind of got an awful lot of that in the papers themselves. Still working on them, and they'll be up as soon as I can. I've got another class that has their draft papers are due, so I think they're more important to get out first, and I'm trying to finish them up tonight. So that was what I was looking for: prosecutorial immunity. When we talk about defense counsel, there's a lot of things that come up with the defense also in their ethical implications. Again, ABA has rules for the ethical rules for defense counsel, and something that every person who works in defense should be aware of. It's interesting that so many defense attorneys, after working with defendants for a period of time, then are pretty convinced that a lot of their clients aren't guilty. When in fact we've seen that a vast majority of those people that get arrested for crimes and prosecuted are in fact guilty, factually guilty. So it is interesting proposition. And then the idea, which is one of the most important parts of this for you to walk away with, is the idea of perjury. And can defense counsel allow perjury? The client wants to get on the stand, and the client's going to say that they didn't do it and they were someplace else, or whatever the defense is. And then what's defense going to do? Can counsel allow that when they know, in fact, that the defendant would be lying? So those are the things I really wanted you to get out of the defense portion of it. This week we talk about judges and a lot of different issues. When you look at the judges on the trial court bench, super busy. I mean, just pounded with cases. And that's one reason why you see the reliance on the crime control model, the assembly line justice. Getting back to what we just talked about, that most defendants are in fact factually guilty. The idea that moving them through the system, through the plea bargain, is important. And that just because the system moves them in this fashion doesn't mean that the system ignores their rights. Got a lot of that in talking about prosecutors, ton of that. I'm talking about crime control model, and that's not true at all. The prosecutor needs to be sure that rights were followed in the field, whether it's Miranda or Fourth Amendment, rights, that the procedural aspects were taken care of. But then if a defendant demands a trial, then the prosecutor just can't say, well, no, you're taking this plea bargain and that's it. The defendant or prosecutor has to go through with the, taking it to trial. And the judge has to hear it. I mean, I'm familiar with a case where a guy goes on a date, meets a girl at a restaurant, and she gets about 4 margaritas in, and becomes unruly and is yelling and screaming and being rude to the waiters and the customers around her. And the guy says, well, I got my own car, so I'll see you. Excuses himself to go to the bathroom and then leaves. She knows where he lives. They've dated apparently before. And so he parks his car a couple blocks away, walks home, turns off all his lights. Hour later, she shows up and is standing out in front of his house screaming. She then gets into her car since he wouldn't answer the door, and then she drops the car in drive and runs it through the garage door, crashing into one of his other cars. He calls the cops, and now she's looking at a DUI charge. And when you get to criminal law, you'll see how that works with DUIs. So she wants to go to trial, and her defense is, he drove me home in my car, drove me to the house, and he did that. I didn't do it. Well, there's all kinds of problems with that defense. The police investigation, what she told the police when she was there, all of this stuff, her blood alcohol content, her conduct in the restaurant, all of those things contributed. But she wanted a trial. But the judge told the defense attorney to let her know that if she gets on the stand and perjures herself, that she's going to be facing the full extent of the DUI law. Plus, if perjury can be proven, then she will also have to deal with a potential perjury charge. So the defense had said, hey, don't say anything. Let them put on their prosecution, but you just better not get involved. And they did, prosecutors. She didn't, and she was convicted. So the judge had to step in and to really set the rule, because he acts as that referee between defense counsel, prosecutors, the witness who was the person being examined, and the attorney who was doing the examining. And then the hardest part about that is being able to make your own notes, do whatever paperwork you're doing while you're on the bench, listen to the questions asked by the attorney, listen to the answers, and or listen to objections, and then be able to apply the relevant law to each of the objections. It's really tough. In my face-to-face class, we do a mock trial, and that's one of the biggest challenges for me when I sit as the judge, is making sure that I'm listening and I know what's going on the whole time. And it becomes a bit of a challenge. Selection of judges, in California, Remember, judges are usually appointed by the governor, and what will happen is the governor will go to the State Bar Association, ask for a list of qualified candidates, and then will make a suggestion, or will pick somebody from that list. And people that have appeared before that judge will have input, and then that process goes to the legislature where the is approved. Now, California has judges by election, and when you vote, in November, take a look at the ballot, because you probably have judges up there. Most of them are unopposed, but some are opposed. And you have an incumbent, and then you have somebody else. And now you've got to try to figure out which is the best person. And my guess is you have absolutely zero idea who it is. So there's quite a bit of discussion as to a better, more efficient way to select judges. And then how long do you make their term? Do they have to run an election? How does that all work? The Missouri plan, which is a merit-based selection process, has to deal with that. How long do you make a person's appointment to the bench? Is it a 4-year appointment? Is it a life appointment? What's that going to be? And then how do you fill that spot if the person wants to stay on the bench? So kind of an interesting twist. And then I guess we'll have to talk to some extent about the Supreme Court process. And it's interesting, a couple things. First off, the process has really changed in the past, maybe the past 3 or 4, maybe further back. William Bork was nominated as a Supreme Court judge by Reagan, I believe it was, and conservative judge, but politics came into play, and he ended up getting another term, getting borked, and not approved for the Supreme Court. Clarence Thomas was another conservative judge that faced some pretty significant rhetoric, at least, in an attempt to keep him from being confirmed. Merrick, I'm trying to think, Garland. Merrick Garland was an appointee by Barack Obama, and ran into the problem of getting enough votes. And then, of course, we have the issue with Justice Kavanaugh. And you can see where the politics has really come into the court, and it's because both sides have existential issues. By that I mean they're issues that they believe have to go their way. Law and order kind of issues. When you get to 350 and your CRJU 350, and you're talking about search and seizure law, you'll see a couple of recent decisions that have overturned decades-old law, decades-old precedent, which is kind of interesting because what does every Supreme Court justice nominee say is that they believe in the idea of precedent. What that usually means is it pertains to Roe versus Wade, and then you see the law change in other areas. Arizona versus Gant was a 40-year-old precedent which was changed, and that's those kind of issues are existential for both sides of the aisle. The other existential issue is gun control, and both sides have really solid beliefs, and they're not changing. You're not going to be able to go to a person who is a gun rights advocate and have them change their mind and decide, no. But I think you probably see more people that are on that side of the argument alter their belief systems than the other side. And then finally, birth rights, Roe versus Wade, existential for many in both parties. There's very, very, very limited middle ground for both parties. So the Supreme Court is highly politicized now. In the past, it was politicized, but the parties realized that if the president had the power to appoint, and then it's absent incompetency in the law that's going to get his way. So an interesting issue with the Supreme Court. Federal judges, Supreme Court judges, justices for life. Although we'll see how much this comes to pass, but there's talk about impeachment of Justice Kavanaugh if they get enough votes. That'll be an interesting fight if it does occur, and we'll see how that turns out. So those are the things I wanted to talk about. I guess the idea of, when you look at the Supreme Court especially, is that judicial independence. The lower courts are not as independent. As a matter of fact, there's a couple of cases that are winding their way through the court system now, and some I think will end up on the Supreme Court docket about whether or not a lower court judge can follow their own belief in a particular issue and not the law. Those will be cleaned up here in the next, probably the next couple of years with these cases that are headed to the Supreme Court. So this week you have a discussion board and a little bit less work for you, but I'll get those papers turned around to you as soon as I can. So with that being said, we will see you all in class.